Mrs. Jackson?
Yes, good morning, Mr. Waxman.
Good morning.
I had thought that knowledge and substantial assistance were two different elements or two different criteria. Am I right that that's the case or no?
I think you are.
You're looking, go ahead.
Yes, you are right. What the operative text says that aiding and abetting by knowingly providing substantial assistance.
All right, so we have two different things. There are two elements, but then your statement of the rule that you explored with Justice Kavanaugh seemed to have them both working in a way that I was confused about. So
let me, I can see how it's confusing. So what's alleged to be your culpable conduct has to have, in fact, substantially assisted the act of international terrorism that injured the plaintiff.
Independent of your knowledge, it has to have
it has to have done
okay.
that. But the statute goes further and says that you have to knowingly provide that assistance, which we think must mean that you must know, A, that you're providing assistance, and know that the assistance you're providing is substantial.
But let me ask you, does it have to run to the particular act? Because at the very beginning in your conversations with, I think, Justice Sotomayor, we were trying to get to this point of understanding your view that the particular tortious act is what we're focusing on, not just general assistance to the terrorist organization. I get that. But if we're looking at the particular act, then you said at one point that you can have general awareness that you're assisting the particular act. And I don't really understand what that means.
I misspoke if I said that.
Okay.
So I think I was trying to explain that under step 2 of the Halberstam framework, you have to, quote, be generally aware of your role as part of the overall illegal tortious activity at the time you provide the assistance.
And you conceded that in this case?
I conceded for purposes of this case that that's established, that's fairly pled in the complaint.
So then what's the knowledge that's working at step 3?
Right. You have to know that you are providing substantial assistance to an act of international terrorism and an act of international terrorism that happened to be a terrorist attack that injured the plaintiff.
But it doesn't have to be the Reina attack. You just have to know that you're assisting ISIS, that ISIS participates in.
It's not just there's a wide gulf between knowing that the location of the attack will be the Reina nightclub and knowing that you're somehow generally assisting ISIS in some
Yes, and it's the gulf I'm trying to explore. So
right.
I want to chart it. What do you have to know in 3 that is sufficient under your view?
Yes, you have to know that you, in fact, I'm sorry, what did you have to know?
In step 3, when you say, we've disposed of 2, which is the general knowledge of your role. You know you have a platform and people are using it and some of those people are bad people.
Got it.
3, you say home in on the act. It has to be act of terrorism. And I guess I'm just trying, that you substantially assist in
Correct.
that.
Right.
But then what's knowing doing there?
You have to know that your action would substantially assist an act of international terrorism. That's the independent work that that you knowingly provide substantial assistance does.
So they don't have to allege, or they do have to allege, that you knew something about the fact that this group was going to do an act of international terrorism that turned into the Reina attack.
That is exactly what they have to plausibly allege and ultimately prove not only that our actions substantially assisted the Reina attack, but that we knew that we were providing substantial assistance to some act of international terrorism.
But not enough to know that you're providing substantial assistance to a group that does this kind of thing.
Of course not.
I don't know that I see that clearly, the distinction, but let me ask you just a quick question about Halberstam. So I guess I'm a little concerned about framing this as the defendant is offering generally available services. What if in Halberstam itself, instead of Linda Hamilton providing bookkeeping services, we had an accounting firm? And their usual course of business was to provide the bookkeeping services. They did exactly what she did with exactly the same level of knowledge, in the sense that they knew that these were pretty, you know, they knew this guy didn't have a job. And suddenly he was showing up with, you know, thousands of dollars in jewels and whatnot, and asking them for bookkeeping services. Are they on the hook or not?
I think they probably would be on the hook. I mean, it's different than Hamilton, where she had no other job. She didn't do anything other than have this symbiotic criminal relationship. But if you had an accounting firm that somebody comes and basically says, you know, I'd like you to help me with the following. I'd like you to help me, you know, smelt down jewelry, and then
No, they're
sell
doing
it.
their usual bookkeeping services. They have a lot of clients. They have very, you know, well-to-do regular clients who do have jobs and are bringing them money. And then they have this guy who starts coming and saying, please, I'd like to do bookkeeping. And they're a little suspicious, but they don't do anything other than the regular bookkeeping services that they ordinarily would provide to their other clients.
I mean, if the circumstances of the services that's being requested and that they provided would not permit a fair inference that they were, quote, generally aware of the role they were playing as part of overall illegal or tortious activity, they wouldn't be liable for aiding and abetting. I do want to just...
Thank you. You can finish your sentence.
Sadly, I'm afraid I did finish my sentence.
Thank you.
Thank you.
Mr. Needle?